And I've had cases where they come in, they're overwhelmed by that, they don't know what to do, so they don't do anything. 20 days pass, and lo and behold, they're stuck.
Let's try to do a little comparison, and I don't know whether this will be good or not because of the way these things are figured. If we were to look on the tables, whether the tables were guidelines out of Oregon or the guidelines out of Washington, if a guy had $2,000 worth of income, gross income a month, he makes $2,000 a month. Let's say he also has 2 kids. Now here's where the problem is. The problem is in computing it, guys. We all know that. But if we used a raw figure, can we make a comparison, Greg, in the first place?
Between Washington and Oregon?
Yeah.
Well, we can if we want to. Washington is based on net after-tax income. Their guideline runs off of after-tax income, and Oregon's guideline runs off of gross before-tax income. So we're going to have to make some kind of an adjustment, maybe knock Oregon down by 1/3 or something like that. We could say, for example, that a father who makes $2,000 gross in Oregon maybe takes home $1,500. $1,500 in Washington. And the other thing we have to fold into this is the custodial parent's income.
Oh, yeah.
Because they get added together for purposes of this computation. And interestingly enough, one of the things that means in my experience is that the more money the custodial parent makes, the more money the non-custodial parent
has
pays.
to pay. It's the mathematics of it. What about your end now?
I don't think that aspect is quite true, but there's some other aspects that go into this too. I don't know about Washington, or Oregon rather, but Washington has a provision in there where if you have a custodial parent who is not working, voluntarily not working, you can impute income to her.
Oh,
and
yeah.
Some levels for that. I don't know if Oregon has something similar to that.
Yeah, we do, but only to minimum wage.
Okay.
Okay.
I understand we have a call or two that's been waiting on the line while we talk about these things, and we're ready to take a couple more calls. We've got more tape. We'll try to get through some of these guidelines issues, and let me apologize for not being any more specific, but this is kind of a general subject. Each particular case is unique to itself. So let's take a call here. And hello, caller. Welcome to the DADS Television Network.
Good evening.
Good evening.
Yeah, I have a she's almost 17-year-old daughter. Since the age of 15 and a half, there's almost a year and a half now, she has not been attending any school at all. She's dropped out. My understanding is child support is for the health, education, and welfare of the child. And I was wondering, is it potentially possible to get some child support relief because she's not been in school, even though she is still a minor?
This is an Oregon issue, is that right?
Correct.
Okay. Let me ask you to take your answer over the air if you don't mind, unless you have another one.
No problem. Thank you.
Okay.
No.
No.
No. The statute in Oregon is very simple and straightforward. Child support is payable until the child is 18 or 21 if a child attending school.
ORS 107.108A.
Yeah.
Now, here's what I think he's getting at. I'm going to throw you a curve.
Uh-huh.
If the child is not attending school and working, what's the possibility of running through an emancipation process and saying the child is now emancipated, and so therefore I'm out of here with my wallet?
Well, the statutes define certain kinds of things that minor children can do that take them out of the recipient's bucket.
Yes.
They can get married. A father, a non-custodial parent...
Wait just a second, Greg. That's interesting. Now, it doesn't go to this caller here, but I had a guy call me. He says he's got a 16-year-old with a woman who's on welfare, and the 16-year-old is now pregnant, unmarried, and she's going on welfare too. And he says, now wait a minute, do I still have to pay child support for my 16-year-old daughter who's pregnant by another man and the state's taking care of his 16-year-old daughter on welfare? And he says, well, this doesn't make sense.
Well, not only is he going to have to continue paying child support for the pregnant daughter and subsequent mother-daughter, But there's a good chance that his child support obligation is going to go up because of the special needs associated with
my goodness.
the cost of child care, the additional costs of raising this infant, if there's any difficulty in the delivery.
I don't want to hear anymore. Is it the same in Washington?
Well, it's pretty much that way. There's not much you can do in that situation, unfortunately.
So if a guy's paying child support to a woman on welfare who happens to have a daughter, and the daughter's a teenager and becomes pregnant, he still has to pay?
I don't know that it would continue on to the teen, or there would be an extra for the teenager in that situation. But it would continue for the daughter.
Okay. I want to get Greg back in the picture here. Now, the special circumstances for which this caller was talking about, if the daughter, in this case, is away from home, earning money, then he would have to go to the state, go to court on a show cause?
Well, he didn't say that she was away from home and earning money. What this caller spelled out, as I recall, was that the daughter simply had dropped out of school.
Okay.
And in those circumstances, doesn't make any difference. He
Okay.
still has to pay support. If the child left home, established her own place to live, had an income sufficient to support herself, and the child went to court on her own hook, because she's the only one who has standing to do this, and sought a court order that she was emancipated, then his obligation to pay child support would end.
I hope that answered that question. I think, Paul, if you're out there, call in with the rest of the question. I think we've got a caller or two on the line, and let's take another caller too. Hello, caller. Welcome to the DADS Television Network.
Hi. I've got a question. My ex is a legal secretary, and she really knew how to manipulate the system.
Okay.
Never marry one. I've been watching you for a couple of weeks, and I just sent off and got a copy of these guidelines myself, and then I switched you on, and here you were talking about it. And I'm looking at this, and I've discovered I'm paying about 3 times too much, just from off the raw table.
Well, just out of curiosity, how much are you paying for how many children?
I've just got one kid, but I don't want to tell, get...
You don't want to say how much you're paying?
No, I prefer not to. But
okay.
Can I
Can't force
recover
you.
any of that?
I'm sorry. Can
I
you
recover any of what I feel like I've been overpaid?
Now, I'm not an attorney, and thanks for asking that question, because I love answering or attempting to answer some of these questions, and this brings out a point. Whether you know it or not, I'm probably being watched very closely by the Oregon State Bar. Many people know that we've been sued by the bar. And some of these issues that we talk about are administrative in nature, and some of them are more legal in nature. And it becomes a very much of a gray area on some of these administrative procedures. But I think that with the aid of an attorney here, maybe I'm protected by saying somehow defer to the attorney, I think that you cannot recover anything that has been paid out unless you go to court with an order and require that the amount be reduced, and they'll probably reduce your amount as of the time that you make the request. But anything that's gone over the dam, so to speak, is gone. Now, Mr. Austin, you're on. Correct me.
Generally speaking, what you said is true. There is an exception to that after the child is 18. If the non-custodial parent is continuing to pay money for a child who's over 18, and the child, it turns out, is not a child attending school, then the non-custodial parent can go back to mom and say, give me my money back because you had a statutory obligation to notify me.
Oh, yeah.
Okay.
All right. And if I'm not mistaken, that's ORS 107.415.
I don't know. It's in there somewhere.
Okay. Any response on the Washington side?
That's basically the law in Washington as well. You
Okay.
can't get it back.
Okay. Do we have another caller out there? If we do, let's take the call. If not, we'll roll on. We've got another piece of footage. I didn't sense that there was a call out there. We've got another piece of footage that I'd like to share with you just to bring the Support Enforcement Agency into it. Let's see, what is this particular piece of footage? Oh, they're talking about the Lord Mansfield law. The Lord Mansfield law actually says, well, let's roll the tape and you'll see it. Roll tape, please.
The old Lord Mansfield law, the old common law, which is codified in Oregon and in most states, is that a child born to a married couple, husband not sterile, not impotent, is the legal child of the husband conclusively. Period. No questions asked. That was probably good law, may still be good law. That was probably good. When I say good, it is good law in Oregon today. When I say good, I meant meritorious. It may be a good idea to preserve that statute, that idea. It certainly was a good idea in the old days when it was very difficult or impossible to tell who the biological father was. For purposes of supporting children, it was probably a very good idea. The truth is today, more and more husbands are saying, I don't care what the law says, I'm not the father of that child. And of course, blood tests, the DNA tests can determine that.
Okay. Again, the Lord Mansfield law assumes that you guys who are married to the women are the fathers of the children that the woman that you're married to. But we know that this is 1995 and that not all women are fully faithful, just like not all men are fully faithful. I might ask you guys, if you were in the legislature, these guys are not legislators, would you consider revising the presumed fatherhood of these guys who are married to the woman and say, okay, let's, in 1995, let's make it an issue that before a guy is ordered to pay child support for about 20, 21 years, that he has an opportunity to verify paternity. Do you think that would make good law, Greg?
Well, part of the problem we're having right here is that the law has been misstated on the tape.
Okay.
What they said there was that this is a conclusive presumption that if the parents are married, then the child is the dad's. And number one, the parents have to be married and cohabitating at the time of conception or birth for a presumption to arise.
Okay.
A disputable presumption.
So are you suggesting then that if a guy is going through divorce, and let's say he's a dark-haired fellow like myself, and his wife has a couple of blondes or red-headed kids that I would say that I probably could not produce, I'd say, well, you know, I got a question about this. Would you, if you were representing me, help me then as the presumed father get out of the child support and maybe someone else's nickel?
Yeah, but I don't think I could do it on the strength of the appearance of the child relative to the appearance of the children.
Well, that would be my first thought. I'd say, well, that's not mine.
Well, that's not going to convince the average reluctant judge.
Well, then what do I need?
You need what's called an HLA test.
Something to do with the blood?
You need about $800 worth of DNA testing.
Okay.
And you need to force mom to bring the child and herself. You need 3 sets of blood, mom's, child's, and dad's.
I need a court order for that because she probably wouldn't do that willingly.
Right.
Will the judge order it on my suspicion?
Judge is not going to want to because of this presumption and because they don't want to clutter the water.
Okay. Anything in Washington? What are my options in Washington if I think that if I have a suspicion that I'm not the father, the biological father of the child that my wife brings into the world, what can I do?
Well, I had a case just recently where my client, the dad, was the presumed father. He was not the biological father, and mother acknowledged that. The state of Washington went in and assessed him anyway as a presumed father. He's coming to me and going, well, now, we know there's the actual father out there. Why aren't they going after him? I said, well, you're here.
The Lord Mansfield rule.
Yeah, you're here and you're easy to get. They don't want to go chase him. So we had to go through an administrative process to get him out of that situation. But
so he went through the divorce. He was getting a divorce.
Yeah.
There was a child that wasn't his.
We had the court proceeding, and then we had the administrative proceeding over here saying, you're paying child support on this child. And we had the court, our divorce action, stating that we didn't even have a child in here.
Okay, so is he paying child support for that child
He
today?
is
or-
not now. He is
Okay.
not. We got him out of that. We got him divorced and got him out of that.
Okay, then the former question comes up that a guy
Okay.
asked, can he recover anything that he put out?
No, he's out. That's just gone.